Good afternoon, everyone. Welcome today's webinar, The Pivot Plan from COVID-19, What Employers and Job Seekers Need to Know and to Survive in a Digital World. I'm Chris Santomassimo from the law firm Santomassimo Davis, Outside General Counsel Solutions. And with me today are my colleagues, Susan Kleiner and Aaron Drew, who will join in the presentation as well. We really appreciate everybody coming to take part in the conversation today. I think the issues that we'll talk about today, it's fair to say, impact just about every employer in the United States and perhaps beyond, thanks to what we're dealing with right now, which is COVID-19. What we're hoping to do is also have a discussion about how we're turning the page from COVID-19, this idea of a pivot plan. How do we get ourselves back into a productive work environment? How do we manage employees in the meantime? And then what do job seekers expect, or what should they expect in the marketplace as they move from an in-transition status back to being employed or starting businesses, et cetera. A couple of housekeeping items. First, I'd invite everyone who has any questions or comments to post those in the Q&A. That's the Zoom Q&A. We'll answer as many as we can during the course of the presentation. Some of the questions you might have actually might be part of our materials. So we'll sort of get through the materials and hopefully answer the questions in the process. If there are questions that we either don't have time for today or are a little bit fact specific, very specific to your companies, what we'll do is reach out to you after the program to set up a time to speak about those and answer, again, continue the dialogue after the program and answer as many questions as we can. Secondly, we'd invite you to give us a call or send us an email after the presentation to raise any issues that you've thought of after the program. We're happy to answer as many questions as we can and provide you with as many services as we can free of charge, just because you were nice enough to participate in the program today, and also we want to help as many folks as we can get through these difficult times. So again, feel free to reach out. And then lastly, you may get a call from somebody on our team just inviting you to have one of those conversations. So feel free to use that as a resource to set up a time slot that works for your calendars. So just the agenda for today, we're going to talk just a little bit about our firm, and the reason I want to do that is just to give you the context from which these issues come, because many of the topics that we're covering today really are sort of ripped from the headlines of our law practice and our role as the outside general counsel for companies. We want to talk about flexibility and documentation as a strategy, vaccines, remote employees from both the employer and the employee perspective, enforcing restrictive covenants, your return to work plan, and then lastly, specific issues for workers that are in transition. So our outside general counsel solution is really an offering in which we make our law firm a virtual law department for mid-cap companies. What we find is mid-cap companies that are not large enough to have their own internal general counsel find themselves in a place where they're reluctant to use attorneys because of high hourly rates, and they wish they had the dedicated services of an attorney acting as a general counsel, managing their legal and regulatory affairs. So what we do is make our firm available on a fractional basis to provide that service for mid-cap companies. One of the ways that we make our services available to folks is through a fixed fee, which again replicates what it's like to have a captive law department in your company. That fixed fee also enables us to get a little bit closer to the business, to really participate in management meetings and strategic discussions, and makes our law practice and legal services much more business friendly, because they really help executives solve legal problems, prevent them in the first place, and again enable us to give you business friendly advice. So as I said, in the context of these outside general counsel engagements, we run across lots of issues in the employment area. In fact, we spend a pretty significant amount of our practice helping executives through employment issues. So the issues that we've included in the slides today really come from a lot of the advice that we've given clients over the last year or so. So where we start from in this whole dilemma that we find ourselves in, we're just faced with a lot of challenges, as everyone knows. Not only is the virus a problem in and of itself, but trying to understand the unclear state executive orders that have been issued in many states, figuring out how those executive orders square with what we're hearing from the CDC, from OSHA, et cetera. So we've got the Fed saying some things and the state executive orders saying things that appear to be conflicting. How do we reconcile those things? So hopefully we're going to answer some of those questions. But the conflicts are difficult to get through sometimes, and the issues are very complex. So the place that we start is to tell business leaders, flexibility is the place you have to be. Being as flexible with your employees as you can, just being prepared to pivot when you have to. Understanding that the playing field is going to change on a daily basis, a weekly basis, a monthly basis. I think you just have to take a breath and be as flexible as you can to manage and balance your business needs with the needs of employees. You know, many of our employees find themselves in difficult situations personally where they've got maybe they've got people in their family that are in transition. Maybe they're working from home themselves, and they may have children that are trying to learn on a remote basis from school. They've got a lot of stuff going on, in cramped quarters in many cases. So you have to understand that there's a lot of stresses on both sides of the table. So to be as flexible as you can is a place that's going to enable you to balance all these needs in a much more friendly way. And then to understand a lot of the issues that we're talking about today. When I talk about flexibility, I don't just mean allowing people to work from home, because I think it goes far deeper than that. What we've come to know is that in order to balance our lives, quite often we work at different times from when we worked in an office. Maybe you've got employees that are trying to put in time early in the morning or late at night so that they can use portions of the day to manage their family issues. That's part of the flexibility equation. It requires executives like the folks on the phone to think outside the box a little bit, to throw away some of the preconceived notions about how people are supposed to be productive or when they're going to be productive, and just, again, give them a platform to contribute to the organization, but do it at times and at a pace that might be slightly different from how they did it in the office. I also think it's important to be flexible because I would expect there to be an uptick in union organizing campaigns. So for those folks that don't have a union presence in their workplace, you should be on the lookout for unions that are trying to organize dissatisfied workers. So the more on the other side of the equation, if you can keep your people happy, they're less likely to pay attention to union organizing campaigns and keep your workplaces union free. In addition to being flexible, I think it's really important for us to be able to document the decisions that we make as we pivot and being able to explain why we made them later. What we're going to talk about later in the discussion is a concern about whistleblowers and folks that feel like they're retaliated against in the workplace, folks that are raising claims in litigation. Many of those folks have been subject to layoffs or their work environments have changed in some way. So we would expect, and we're already seeing an uptick in litigation related to employment and folks that have been terminated or laid off as a result of COVID-19. So what we want to be able to do is document why we made the decisions we made in terms of sending people to a telework environment or deciding who would be laid off or who was subject to a plant closure. Documenting those decisions is really important so that you can explain later in the context of litigation that you did not have discriminatory intent when you made those decisions. Also, when individual employees are requesting accommodations, either because of a fear of COVID or because they physically need certain accommodations, going through your normal process and documenting the decisions that you make as you respond to those requests is very important. Again, to be able to explain the decisions that you made and justify them and make sure that they're consistent with the law. Now, be careful. The notes and records that you create in this area are usually not going to be privileged. So if there is litigation, you should expect that the documentation you create is going to be produced to an adverse party. But that doesn't mean you shouldn't create the records, because I think the value of creating those records far exceeds the concern about producing them in litigation. And just be careful about your reopening plans. I know there's folks from different places in the country on the call today. I know we've got folks in North Carolina, for example, that are represented. So that the rules in North Carolina are going to be different in many cases than Pennsylvania and New York and New Jersey and California. So be careful to know what your state's requirements are to decide whether you can open in the first place. And if you do, what measures you need to take in the workplace to keep people safe. And we're going to go over those requirements in just a minute. The hottest issue, I think, in the legal press in the employment area is the COVID vaccine, and that is uh, sponsored programs to get people vaccinated, either efforts to get people vaccinated or programs to require that they be vaccinated. So this is an example of how the rules have changed in response to COVID. Before COVID-19, the idea of requiring vaccination would be considered a medical exam under the ADA in some cases. But thanks to an EEOC update in December, the EEOC determined that the COVID-19 vaccine is not a medical examination that would require a disability analysis in terms of whether somebody is subject to it. But again, one of the biggest issues is, do you require your employees to get a vaccine, get the COVID vaccine? And what do you do if they object to it? Just by way of background, this is probably one of the most polarized issues, I think, in the last few months, this idea of whether the vaccine is safe. How was it developed? The fact that it was developed so quickly has caused some alarm. But in addition to some of the fears around the vaccine and how it was approved by the FDA, there's a lot of political overtones on this issue. So I think you need, as an employer, you need to keep those things in mind as you make your decision about, do I require my employees to get it and why? And what do I do if they object? So just know that there's a lot of emotion attached to this issue. As I said a moment ago, the EEOC said in December that it's not a medical exam in and of itself. But keep in mind, though, that if you do ask your employees to provide medical information in terms of pre-screening questions, that you may create a situation in which there would be a concern about a medical exam because you're asking people to disclose information about their medical conditions. The first decision I think that you make here, or the first part of the analysis about whether you require the vaccine in your workforce, is whether there's a connection between the getting of the vaccine and some work-related requirement. So we see this happen pretty frequently where healthcare providers and first responders in many jurisdictions are required by their employers to get vaccinated for the flu because there's a direct connection between minimizing the transmission of the flu in the healthcare environment, for example. So as an employer, when it comes to COVID-19, you need to decide, is there a job requirement? And can I justify the connection between the job requirements and getting the vaccine? I think once you get outside first responders in a healthcare environment, just my own opinion, if you've been able to operate successfully during this whole pandemic without too many interruptions, I think it's going to be a little bit difficult to make that direct connection between the job and the need for the vaccine. So I would just be cautious about whether you're going to mandate this for your workforces. We are starting to see this, though, even in largely administrative environments. We've seen law firms now that are requiring their attorneys and their other staff to get vaccinated before they return to the office. Again, those folks have been able to work pretty successfully in a remote situation. So the firms that decided that the safety or the need for safety coming from the vaccine outweighs any inconvenience to the employees for getting it. So what we're telling clients is be very careful about mandating it. In fact, if you're on the fence about it, you may start with a program where you're suggesting or you're highly recommending to your employees that they get vaccinated as soon as they're able under the state regulations. All right. But you got to be, if you're going to mandate it, if you decide you're going to, you need to provide for religious exemptions and also physical limitations that would prevent some of your employees from getting vaccinated. So those need to be part of your program. And you have to be ready to evaluate those requests for exemptions as they come in. Also take a look at your collective bargaining agreements to see if there's any kind of requirements related to unionized employees. And then a question has arisen about whether there's some employer liability for requiring a vaccine. I think that's an unsettled issue, quite frankly, and whether it's going to be covered, whether any injuries that would stem from a mandatory vaccination program and whether they're covered by workers' comp is an unsettled issue. So we've got a couple of question marks around those issues. Now, discussing some issues related to remote workers, I'd like to introduce my partner, Susan Kleiner.
Hello, everyone. Thank you for joining us here today. So in speaking about remote workers, back in March of last year, who would have thought, that we would still be here in these unprecedented times and still talking about remote workers? Interestingly, I would say, probably the majority of my clients at the start of the pandemic didn't have a remote work policy on the books. And I think that that's probably pretty typical, at least in this area, maybe somewhat different out in other areas. So if you don't have a remote work policy, you should get one. You should create a written policy. And, that policy, as with other policies and handbooks, say that it can be amended or eliminated from time to time. Even when you have a policy, though, you have to keep in mind that, we need to be flexible, just like what Chris was saying before. And, that policy may also provide some information about, what we do with regard to home office expenses. The remote policy can also be really important, and we're going to talk about this in momentarily concerning having employees make sure that they mark all of their time. One of the things that Chris was talking about before with documentation is, the importance of documenting transitions. Similarly, it's really important that you document, how you do what you do, although you can't expect those documents to be privileged. In other words, we have to make sure that we act in an equitable manner, but we have to be prepared to explain why we've done what we've done and treat similar people similarly. I think it's also really important to make sure that even though we are operating remotely, we're continuing to enforce our workplace policies, we're continuing to do reviews and performance management, and that we've taken care of everything. But, if you didn't have a remote policy before, I think that COVID has demonstrated to us how important it is to get that done. Chris, you can switch to the next slide. One of the issues that we have seen, and granted, this is all real time, that we are encountering some issues with the Fair Labor Standards Act with regard to overtime pay. So this was clarified somewhat by the USD Department of Labor in August of 2020, but the employer has to pay for work that the employer knows or has constructive knowledge was performed. So that's an issue of actual versus constructive knowledge. And that's one really good reason to make sure that employees are logging their time. Because if they haven't logged it, then how can you know? We also have to make sure that there are policies in place regarding overtime and off work hours, and you have to enforce it. For example, if you know that you have an employee that is working way more hours than they are supposed to, you need to enforce your policies and say to the employee, even though we're working remotely, it's important for you to take care of yourself. It's important to stick to your stated work times, etc. And again, you have to remind employees that it's important to take meal and rest breaks, at least for those non-exempt employees. So it's really important, that the employer makes sure that, it stays abreast of what's happening with the employees, that the employees aren't working all the time. Because if the employer has knowledge of that and doesn't pay the overtime, the employer subjects himself or herself to potential liability. So one of the issues with remote work that we're also seeing, come to the forefront is when we're having employees work from home, are they working in a safe manner? And interestingly, there is questions about, is there a duty to provide a safe workplace? And does that apply to remote workers? And the truth there is yes, like OSHA would say that there is a duty to make sure that remote workers are working safely. So what can the employer do? Well, the employer can make sure that there are periodic reviews of the employee's work area to make sure that they're minimizing all hazards. And the employer should also be flexible when the employer can be flexible. Maybe there's something that the employer can offer the employee to make it a safer workplace. The entire time, though, we have to be so aware of the need for flexibility. So many of us are operating at home with trying to manage childcare and schooling, and the employer has to be flexible with those arrangements and be flexible with the workplace itself. Another question, another important issue is that the employer must continue, while it's monitoring, what the employee is doing, the hours worked. The employer must also continue to offer training programs, such as anti-harassment programs, or even like an OSHA workplace type survey to make sure that employees are acting in a safe manner. Next slide. From the employee's view, remote working is not easy. I'm sure that many of us could chime in here on the difficulties of working remotely. And, we'll see more and more studies come out, that are coming out now regarding the effect of remote work on employees. I took a look and I found at least 2 new studies that were talking about the psychological impact of teleworking versus office-based work. And at least the studies that I was looking at said that the results are not good. There's a negative emotional impact of teleworking, particularly in terms of loneliness, irritability, worry, and guilt, and that teleworkers experience more mental health symptoms of stress than office workers and slightly more physical health symptoms. And I think for a lot of people, that comes as somewhat of a surprise. I think that people often used to think that remote working, was a great reduction in stress because we're reducing some time constraints in terms of commuting or, issues in the office. And I think exactly the opposite is being studied now, that, working from home, even though we're giving up the commutes, employees are still reporting issues. There's been some other studies too, also saying that in addition to this, increased stress, we're now seeing and questioning whether or not, are workers working as productively remotely. So all of these issues, that an employee is facing with isolation, technology, time management, and distractions make everything pretty difficult. There's more bad news too, and we're still seeing what the effects of this are, but there's going to be questions increasingly regarding taxation for employees. Now, income taxes vary by state. The general rule for withholding state income tax is for employers to withhold income tax for the state where the work was performed. So that's interesting now. Like if we have a workplace that's in New York, and we know that our remote workers are now elsewhere, that could subject the employees to additional taxes. So again, if there's questions about this with regard to your specific workplace, it's really important to get on the call with us or your accountant to make sure that you're doing things right. And obviously this affects both the employer and the employee. Another question facing employers and employees regarding remote work, we saw, this mass exodus from New York City, where New York City employees were leaving and going elsewhere. Since you can perform the remote work anywhere, why stay in New York City? I think employers are now going to be questioning whether or not the pay scale needs to be adjusted based on not where the main workplace is, but where the employee is actually performing the work. So that's another issue that we'll continue to see in the future, and we're trying to figure things out. Next slide. Of course, one of the biggest issues facing both employers and employees is privacy and privacy issues. We know that with remote work, so many people are trying to juggle taking care of their children, trying to make sure that the kids are signed on to Zoom and going to school. And at the same time, they're expected to do their work. So how is it that an employee can make sure, that they keep all of their information safe? I know that, Aaron, I don't know if you wanted to chime in a little bit on this. I know you had some thoughts on policies that employees could implement.
Sure. Welcome, everyone. I'm Erin Drew, another attorney in the firm. With regard to working from home and actually even working in the office, you need to decide and look at whether or not you have a clean desk security policy. And I'm sure you're all thinking, great, yet another policy to be thinking about. But the truth to the matter is we do need to be thinking about whether or not we have a clean desk security policy. And that would just look at how employees must leave their desk or their workstation at the end of the day. And why would we want to do this? One, it secures sensitive data. Perhaps you're in, have financial data or personal data related to employees or customer data, medical information, strategy, trade secrets. There's a number of things that you would not want to be exposed to visitors to the workplace or even to potentially other employees, depending on what that person's role is. A clean desk also increases productivity, efficiency. People aren't looking around. They're not spending time looking for documents or information. At the end of the day, they put things back where they belong. So when they then need them 2 days later, 3 days later, they can find them. Less paper. You want to try to be as digital as much as possible. There's lower cost. There's less chance of papers flying off of a desk, off of a workstation, somebody else picking up a piece of paper and walking off with it. It also makes the workspace more presentable for those who come in. And finally, ISO does have an information security standard where you can get ISO certified, and there's a framework for a clean desk policy. It is part of the certification. So if you have this and you're thinking about this at the workplace, you really also need to be thinking about what's happening in an employee's home. Are the documents being secured? Where are papers being left out overnight? You want people to be securing the paperwork. You want people to be securing the data. So just as you would have a clean desk policy in the office where you have people leave their desk clean, lock away important paperwork, you want people to do the same thing in their homes. You want them to put important paperwork in a safe spot where a visitor, a child can't come and grab the piece of paper and write on it and use it for homework or scratch paper for doing math. You don't want someone, who has come into your home. Maybe you have an office space to grab a piece of paper, see a document that has a client's personal information. So you want your employees at home to be doing the same thing. Locking the computer when stepping away. We've all heard of things where with students at home, with children at home, working from home, could they accidentally take the family computer and log into it to play a game? And that's the computer that's being used for the employees' remote work. These are things that you need to be thinking about. Do you want your employees shredding certain documents after they use them at home? What about home printers? Did they leave a document on the printer? And again, never use an open Wi-Fi network. These are all things that we should all be thinking about as we are working remotely and as our employees are working remotely.
Yeah. Erin, I think it's also, for sure, like that's all important. Another important thing to add here is that, hopefully everyone on this call makes sure that their employees have signed confidentiality policies or it's a part of their handbook. Probably a good time to take another look at that. And to the extent that it's necessary to address some of these issues, to add it to your policy. Another really important thing to note, and you mentioned it, somewhat there, but is to make sure that we are continually reminding our employees regarding privacy and cybersecurity threats. I mean, these hackers are getting better than ever in terms of their phishing schemes and ransomware, and it can hit an employee working remotely, just like it can hit an employee in the physical workplace. So this is a good time to take a look at those policies, make sure we're training our employees and making sure that our data is secure. Another interesting aspect of remote work, and I definitely hear this coming up with some of our clients, has to do with monitoring remote employees' activities. And I think that the rule of thumb here is if you could monitor them, in your physical location, for example, with like keystroke tracking, it's okay to also do it remotely. Again, this is new times for all of us, and I think that we need to be careful. But in general, I think courts are going to allow some monitoring. Certainly okay to have time clocks, certainly okay to have keystroke tracking. It's another question about whether or not cameras would be allowed. I think that if you have a specific question about cameras, you should give us a call, because I know that I, for one, would want to take a look at whether or not where the employee is working is a one-party or two-party consent state. And we're still figuring out all of this. But in general, it is okay to monitor your employees to make sure that they're doing work.
Susan, may I follow up with a question?
Yes.
With regard to the keystroke tracking, when you're talking about that, are you talking about that on a company-owned laptop or a company-owned device versus a family device or a personal device that is then remoting into a employer workstation, or remoting in to the employer database?
That's a great question, Erin. I think it's definitely it's easier if the person is working on a company laptop, a company computer. Having keystroke tracking, certainly allowable, because I think at that point you could say, listen, it was an employer sponsored machine and we are allowed to monitor. I think that when it is use of a personal laptop or a family laptop that is remoting into employer software, if it is keystroke tracking only during the remote connection period, probably okay. But if it is keystroke tracking of everything, maybe not. Actually, probably not a good idea. And I think that most employers wouldn't want to see that anyway, or at least I'd hope not. So keystroke tracking is good for a company sponsored laptop, but I would be very wary of recording everything on the family machine. Next slide, please. So here's a really interesting area, and we're waiting for litigation to catch up. Obviously, we know that there have been a lot of court closures and things are happening still in courts, and there's Zoom proceedings, etc. But litigation takes a while to catch up with what's happening in the real world. And I would say that restrictive covenants are no exception to that. So here's the question. A restrictive covenant is where the employer has had the employee sign something that says, I promise, that I am not going to work for a competing entity for a certain period of time in a certain geographic area. And the question that's coming up is whether or not courts will hold restrictive covenants enforceable given the COVID-19 pandemic. I think one of the distinctions to make here is that all of these rules concerning restrictive covenants are dealt with on a state-specific basis. For example, some states are much more likely to enforce restrictive covenants than others. For example, are you going to be able to get a restrictive covenant enforced in California? No. What about in Massachusetts? Well, there's a difference in Massachusetts with exempt and non-exempt employees. And then the District of Columbia had a new law passed on January 1st concerning restrictive covenants. So again, this is an area that if you think that you have an issue or you may have an issue, give us a call and we're happy to look at the state-specific rules. In general, restrictive covenants are held enforceable to the extent that they are reasonable in time, in geographic scope, and in scope generally. If an employer has a restrictive covenant and has laid off its workforce because of lack of work for COVID-19, I believe it is less likely that a judge would enforce a restrictive covenant. And that is because most courts will agree that your employee has got to eat. And while we want to keep things fair, unless there's a very long severance period, and if there's been like this major layoff, it is less likely that a judge would hold a restrictive covenant enforceable. So those are like the non-compete, non-solicitation covenants. With regard to confidentiality, which is also considered sometimes a restrictive covenant, courts will definitely continue to hold those enforceable, regardless of COVID-19. I just want to note here, though, that the case law is certainly developing. Prior to this webinar, I did a search nationally and found very little case law on this issue. One case from the Eastern District of Pennsylvania found that a non-compete wasn't enforceable after there was a company-wide layoff. And also in the Northern District of New York, the Adecco case also found that it was non-enforceable. So here judges are, trying to be equitable, trying to make sure that, employees can pay their bills. And if an employer has terminated an employee because of COVID-19, it is less likely, in my opinion, that overly restrictive covenants will be held enforceable. Next slide. And at this point, I'm going to turn it over to my colleague, Erin Drew, and she can talk a little bit about the return to work plans.
Hello. Okay, so, with regard to the return to work plan, you're going to hear me state something that you've heard both Susan and Chris say repeatedly. You need to know your state and local requirements. I understand that we have people from New York and DC and Connecticut, as well as New Jersey and perhaps New York on the call. So you need to really know what your state and local requirements are. You can obviously look to the CDC and OSHA for safety and hygiene practices, and we encourage you to do so. The OSHA has sent out a new guidance. It's really just an update. There aren't many new things on here. They updated their guidance on January 29th. And what you see is the typical things that we've been dealing with all along. Maintaining a social distance, good hygiene practices, making the good hygiene practices easy for employees by having hand sanitizer and soap and sinks available for them. But what the OSHA does say is that you should actually sit down and create a plan. And and have it be a return to work plan that looks at your protocol with regard to COVID-19. And so you should have a workplace coordinator, somebody who's going to be responsible for the COVID-19 issues on the employer's behalf. And while you're creating this plan, you do want to engage with some key employees, as well as if you are in a union situation, obviously a union representative, just to get their input as to how to craft the return to work plan. Again, as I said, this return to work plan, or rather the OSHA guidance, doesn't really have many new things, but what it does have that is new is it states that an employer should consider providing the vaccine at no cost to the employees. Now, they're not mandating employers to do this, but they're encouraging employers to look at whether or not they will be doing this. And they want you to consider making it at no cost to all eligible employees, and also provide information and training on the benefits and safety of vaccinations. Does this open up the door to employer sponsored vaccinations for other viruses? No, I don't believe it does. And as I stated earlier, it is not mandated. It is just a guidance at this point. They also state that you cannot treat workers who are vaccinated different from those who are not. That's pretty obvious. You don't want to treat one population different than the other. However, this means that those workers who have received the vaccination still must wear a face covering. They still must social distance. Right now, this vaccine is not, it's not an immunity card to do whatever you would like to do. They're encouraging people still not to travel, not to get on a plane, even though you've got the vaccination. So this is all still new and developing. So you cannot treat those who have been vaccinated differently from those who have not been vaccinated. I do think that this guidance is possibly a precursor to what the new administration is going to require employers to do. The Biden administration has asked OSHA to look at the return to work guidelines, to look at the vaccines and come up with more than just guidelines, come up with actual requirements that employers must do. And the last date I heard was March 11th or March 15th as a deadline for OSHA to come up with those. So we will keep our eye out looking. This is an ever expanding and ever changing field. So we're going to keep our eyes on that. As far as the other avenues of the return to work plan, you have to have a strong anti-retaliation plan. And Chris is going to talk about that a little bit further. You have to continue on with social distancing, de-densifying workspaces. You have to plan for positive COVID cases to happen and suspected positives. And what's going to be your reaction? What's going to happen? You're going to send that employee home, and they're going to quarantine until they either come back, have a negative test, or they test positive, and then they have to wait until symptoms resolve themselves. One thing that you should be looking at is many of the states have really good websites as to what the quarantine requirements are for employees. And they set forth what an employer should be looking for, how many days after the last symptom, how many days or hours after a negative test. If you have questions about your state-specific policy, please give us a call. We'll help walk you through it. We can help you devise a return to work plan. Again, there are some great materials out there to get you started. But when you have fact-specific questions, please don't hesitate to give us a call. Chris, if you could do the next slide. Great. Protecting employees and creating a safe workplace, that kind of goes hand in hand with that return to work plan. You need to have non-discriminatory policies. You can't make selections based on susceptible populations, older workers or those with pre-existing conditions or disabilities. However, with that in mind, you do need to recognize that you may need to make certain accommodations for those susceptible populations. As far as the PPE is concerned, there's an OSHA standard out there, and we have the website up there, and it depends on the context. It depends on what is occurring in the workplace, what that employee's job responsibilities are. And as far as having face coverings, there is an OSHA standard on the respiratory protection, but both the CDC and OSHA are strongly encouraging face coverings. And employers in New Jersey, can require medical documentation from those employees who say they cannot wear a face mask due to a health concern. And if that employee cannot provide medical documentation setting forth why he or she cannot wear a face covering, the employer can deny entry to the work site. So that's important to know.
Hey, Erin, can I just jump in now? This is a good question for you or Chris. It came in the chat, and that is because you're talking about, documentation from your employee on health issues and mask issues. And we got a question about whether or not you should take the word of your employee that they were actually vaccinated. Can we ask employees to bring in their vaccine cards to actually show that they were vaccinated? I mean, is that a good idea, Chris and Erin?
You actually can request verification that people were vaccinated. Just in my own opinion, Erin may think differently, but I guess it depends about whether you want to do it or not. If people give you a verbal yes, they've gotten vaccinated, and you don't take that as gospel, but you ask for something in writing, I guess it depends on the population in terms of how it's received. But you can do both of those things. You can make a verbal inquiry as well as ask for written documentation.
Chris, I would agree with you there. I also think that the context matters in that, are you requesting this because you've taken the position that I'm mandating vaccines for our workplace. I think that right now you can, according to the EEOC guidelines. I think that as employers go back to work and some choose to mandate, we're going to see this play out more and more, and we'll go from there.
Right. If you do request people to submit copies of the card or copies of the verification, you just got to be careful about how you store it, because you're now coming into contact with personally identifiable information and medical records. So you have to protect those from disclosure.
Right, exactly. Any of the medical records that employers obtain from their employees, they must be kept separate from the employment/personnel files. There's two separate files that are kept. One's a medical file, the other is a personnel/employment file.
Right.
Jumping back to the slide, we've talked about the CDC and the OSHA guidelines regarding good hygiene, temperature checks, density, 6 foot separation, putting up barriers where you cannot keep the 6 feet separation, the face coverings. All of that has been in place all along, and nothing there has really changed. But, as I stated earlier during the last slide, you really want to have a plan in place as to walking you through from opening your doors to how we're going to handle one positive case, how we're going to handle if there's an outbreak within a department. You need to think about that before your doors are open, because for some employers that happened, and it happened fast, and they were thinking on the fly, and some may not have been happy with the decisions they made on the fly. So it's better to come up with a plan now. And while that plan may not go perfectly as planned, again, we're hearing the word, the key word of 2020, and it looks like it's going to be 2021, is flexibility/pivot. And we're going to have to be able to do that. But at least having a plan in place when you walk in is going to help guide you there. New Jersey has recently passed a bill providing for a rebuttable presumption that essential workers who caught COVID in the workplace. That means that the presumption is going to be that the essential worker caught it in the workplace, and the employer can rebut that with evidence, showing that the person caught it elsewhere, whether it's a family had it, there was a large gathering, there was out-of-state travel in a high risk zone. Essential worker, that's your standard fire, medical, the grocery store worker, the gas station attendant, those people who were at work all along when the emergency first took place. However, there is, of course, that catch-all phrase, any other employee deemed essential by public authority declaring state of emergency. So it kind of, creates this unknown as to who exactly is going to fall into there. While at first this seems, and it certainly is an employee-friendly amendment to the bill, employers, it could insulate employers by invoking the workers' compensation ban on recovery. So while it is employee-friendly, it could insulate employers somewhat. Again, provide PPE and supplies, investigate any complaints that protocols aren't being followed, follow up with employees on that, minimize visits from outsiders, the self-screening and documentation that others have followed, continue on with that. But again, keep any type of medical information separate. You want to make sure that you train the managers and supervisors to enforce the protocols. Don't, let Joe in one department let his employees get away without wearing face coverings, while, Jerry in the the department down the hall enforces it strictly. And then we're going to talk about whistleblowing separately, and I think that's a good time to switch over to Chris.
Thanks, Aaron. So in terms of anti-retaliation and whistleblowers, this is a pretty hot topic in the age of COVID. What's interesting to me is there's nothing really new here in terms of how you should be running your business and how you should be managing your workforce. But I think the need for a strong policy and a strong program around anti-retaliation is really emphasized thanks to COVID. So we're going to talk about some things you probably have heard before, and then just put them in the context of COVID. So just one data point. I sat through a program not that long ago, and the speaker discussed the fact that about 80 to 82% of the the new filings for employment claims in the New Jersey Superior Court related to whistleblowing claims. So, more than 3/4 of all those claims focused on whistleblower, and they were all COVID related. So that's just one data point to suggest that there has been litigation already, and there's going to be more litigation where the whistleblowing claim is really central to the case. Why is that the case in many states? It's because the anti-retaliation statutes or whistleblower statutes provide for special damages, punitive damages, attorney's fee awards, and it's sort of a sexy topic, certainly in the age of COVID. So it's definitely something that should be on the radar screen of executives and people running businesses for sure. And the COVID related claims, and this goes back to what Aaron was just talking about, they relate to things about complaints on safety practices, the availability of PPE, on what basis the PPE is distributed or recycled, return to work plans, et cetera. So you've got this crazy combination of people that are fearful about going back to work, employers that may desire that they go back to work, conflicting messaging out in the marketplace. So when you get all those things together, people raise their hands and complain about certain things. You may not realize it, but they may be making themselves whistleblowers. So anytime, I would tell you, just as a rule of thumb, anytime anyone in your organizations raises his or her hand to complain or raise a concern about something related to COVID or PPE, et cetera, you got to take it seriously, treat that person as if they are a whistleblower and process their complaint, bring it to a resolution, investigate it as best you can, and treat it seriously. All right. And then we'll talk about some other pointers as well. Because it's a fairly easy standard in most cases for the employee to succeed on a whistleblowing claim, because all they have to show in most jurisdictions is that the alleged retaliation was at least a contributing factor or a portion of why that person was let go. And that's a fairly low bar to get over. So what does that mean in terms of practice? If you're going to lay someone off, and there's a possibility that they could be a whistleblower because they raised a complaint, you have to go through the process of number one, evaluating the complaint that they raised, and number two, understanding whether there's any risk of a claim before you decide to lay that person off. Hopefully, what you've done is to evaluate whether or not there's an independent basis to lay that person off, or to penalize that person for performance. But when there's a whistleblowing aspect to it, you really got to make sure that your analysis for the non-whistleblower or the non-retaliation area is really buttoned up before you take action against an employee who raised his or her hand. Because the risk, as I say here on this slide, really lies in the mishandling. You can manage the risk, but you got to handle it. You got to handle it properly. Having a strong policy is very important as well, just from the get-go. Not just having a policy on paper, but making sure that the policy is implemented and it's really lived up to within your organization. Having training around what practices they should follow in the age of COVID, as well as reminding them about how to report concerns, how to address concerns, and reminding them about the strong policy against retaliation. All of those things are really important. It's even more important when people are dispersed and working from home and they don't have those central workplaces to see posters and reminders or participate in group training programs. So you really need to make sure that we're doing everything we can to communicate these concepts to your workforces for sure. You never want to quash a report. In fact, you want to encourage employees to report. And that's part of that reminder I just mentioned. Remind them how to do it. Remind them that when they report, their reports will be taken seriously, handled, processed, and they're not going to be subject to retaliation or discipline just because they made a report. So this is one area that I think we can do a lot to manage the risk and prevent the claims from actually materializing into litigation. So as our last slide, just a couple issues we wanted to mention. This is not an easy marketplace for folks. In fact, it's the toughest market since the Great Depression, according to Forbes. There's a lot of other ways it's been described as an employer's market, that it's difficult for employees to get jobs and be seen, and Some of the things that you saw in the marketplace before COVID in terms of, the difficulty in applying to jobs online and sort of getting lost in the abyss. I think that's ever more present now. So we need to support each other out there. But also there's a couple of things that we've seen some of our clients do just to sort of make themselves seen, or what some of our clients have told us made good impressions on them from candidates that were looking for employment. Maybe, by the way, it may be a time to think about some of these booming industries. E-commerce, home delivery, cybersecurity are very, very hot for the reasons that we talked about earlier in the program. But just a couple of pointers. Standing out from the crowd is really important. And one of the ways that I've been impressed personally is when people use Loom, Loom, as one tool to create videos, demonstrate who they are, and bring some personality to their applications. There's lots of other tools besides Loom out there, but that's one that I've seen that works really well. Again, it's something that not a lot of people are doing, but if you can do it to accentuate your application, all the better. Secondly is networking. I think sometimes when we're in transition, we feel a little bit reluctant to reach out to our networks. Maybe there's embarrassment or humiliation or just general depression about being in transition. I would say that this is a time when we ought to help each other and help each other create networking opportunities, as well as be ready to help each other get it, network into companies, network into opportunities. Any way that you can do that helps you avoid these mass applications I talked about earlier. And also just as a way to sum up, we're here to help with, helping you through exiting an employer, entering a new employer, reviewing documents. If there's ways that we can help folks on the phone network into companies, or, help you open up doors for new opportunities, we'd love to do that on a pro bono or a free basis, however we can. Again, it's just all about sort of supporting one another and making sure that people get all the opportunities that they can. So I think that's it for today's program, folks. I don't see any more questions on the chat, but again, as I said at the beginning of the program, please don't hesitate to reach out to us. Check out our website, and all of our contact information is there. Give us a call if you'd like, but we'd be happy to answer any questions that we can, again, on a free basis, as much as we can. So feel free to reach out with however we can help you. Maybe we actually had one more chat question. No, I think we've answered them all. So again, thank you very much for attending today. This will be the end of the program for today, and we look forward to staying in touch with you all. Stay safe.